Hello, I'm Jeff M. Brown, the legal writer at the State Bar of Wisconsin. I'm here today with Janis Puracal. Janis is an adjunct faculty member at Lewis and Clark Law School. She's an experienced litigator, and she's the executive director of the Forensic Justice Project. She will be presenting on firearms evidence, challenging the evidence pretrial and beyond at the Forensic Justice Institute in January. Welcome, Janis, and thanks for talking with me today.
Thank you for having me.
Your entry into the world of forensic justice was a very personal one. Your brother was wrongfully convicted in Nicaragua in 2010. What was that like? How did you even know where to begin to help to get to work help freeing him?
Jason's wrongful conviction was the worst nightmare of Jason's life as well as our entire family's life. It was just an emotional time for all of us. Jason spent nearly 2 years being slowly starved in that Nicaraguan prison. And so for us on the outside fighting for him, it was always sort of a question of what was going to happen first. Were we going to get him out of prison, or was he going to die in prison? So that was definitely the most difficult experience of my life. When I first started doing that work for him, I was definitely just spinning my wheels. I had no idea what I was doing. I was a civil litigator in Seattle at a big firm. I had no background in criminal law, no background in Nicaraguan law, and I didn't even speak Spanish at the time. So I really had no idea what I was doing, and it definitely took a village to get to the point where we felt like we were getting some momentum and we were getting towards exoneration. So we had a lot of people consulting and working with me on different aspects of the case. And that was really how we got to that result, by all coming together as a team. And that team spanned multiple states, multiple countries. We had human rights lawyers in Washington, D.C. We had investigators in Nicaragua. We had public relations people. I mean, it was definitely a huge effort to get to that point.
Now, did you go down to, I'm assuming, Managua and actually file some things and argue in court? How did it all go?
I would travel to just outside of Managua is where the prison was where he was being held at La Modelo. So I would travel down there to see him in the prison. I'm not licensed in Nicaragua, so I wouldn't be the one arguing in court. We had local counsel. I was working with that attorney to set up the defense in Nicaragua, and then also working with other folks to set up our international actions, for example, in the United Nations and things like that.
Interesting. And what type of system do they have down there? Obviously not, I'm assuming not common law like the Commonwealth and America. Is it something akin to what they have in Spain? Is it a civil law system? What are some of the differences?
I don't know how similar it is to Spain. I would assume it's very similar, but I know that they had, for example, some of the same constitutional rights that we have, but they weren't being properly enforced. And so we would see those themes again and again. One of the important differences for us was that there was no constitutional right to counsel. So just trying to find an attorney locally to represent Jason and to fight for him was a really, really difficult experience for us. And I ended up reaching out to my colleagues in the US and asking them, tell me who to talk to in Nicaragua. And that's how we found the attorney who became really a tight partner with us and worked with us the entire way through Jason's case.
What role did forensics play in your brother's case? Was there an issue with that?
We did have issues with forensics in Jason's case. One of the big issues was that Jason was charged with international drug trafficking, but they never found any drugs or any trace of drugs. But they tried to offer just a screenshot from a test that they said that they had conducted that showed some type of particulate, which they said must be cocaine. And what we did was we backed up from there and realized that the same screenshot that they were offering against Jason, they were offering against multiple other defendants. So nobody knew what this unknown particulate was, where it came from, who was it associated with. So we definitely had some misleading forensics being offered in Jason's case that we had to fight against, and it took a lot of investigation just to figure out the basics of what was coming into the courtroom and how were we going to fight against that.
And so that was the police and the prosecutors offering that and wanting to rely on that evidence.
Yeah.
Tell me a little bit about your work with the Forensic Justice Project.
So I started the Forensic Justice Project as a nonprofit in 2018. And the reason that I do this work obviously is very personal. It's because of my brother's wrongful conviction. But after Jason was exonerated, I started working on other wrongful convictions in Oregon and quickly realized that one of the biggest hurdles in innocence cases is that I would come into the courtroom and try and argue about forensics being unreliable to produce the conviction. And I had so many judges just either give me this look or explicitly tell me that they had been seeing this stuff for decades. So don't come in here and tell me that I've been doing it wrong. So that was a big challenge for me in innocence work. And I realized that we need to look at forensics, not just in post-conviction, but we need to back up and look at it pre-trial and be educating courts before this stuff comes into the courtroom about how it's unreliable. We need to be training our judges and our jurors to question this stuff instead of just accepting it wholesale.
And it sounds like what you're describing is less evidence being accepted because it has the imprimatur of authority because it was submitted by the government, but being accepted because it's habit. I've been accepting this type of evidence for 30 years since I came on the bench.
That's right. I think that, and I don't think it's exclusive to judges. I think that we as attorneys as well, we get trained to just accept things because that's how they've been done.
Well, certainly, and I'm someone who was never a litigator or a criminal lawyer. All I know about that sort of thing is what I see on Law and Order and other television shows, right? But I think a lot of people who watch those television shows and other shows and popular culture and media know about the twists and the grooves of ballistic evidence because sometimes that figures into episodes. So is that an example of the type of evidence that people just accept on habit, maybe uncritically?
That's a great example. So, we've been offering in criminal cases firearms comparison matches for more than 50 years, and the science has never changed. So when you think about that and just take a step back and you think about, wait, there have been all kinds of advances in medicine and technology and even other forensics, but the science of how we compare bullets and casings has never changed. That's just not reasonable. It just doesn't make sense. And so that's a great example of we accept it because it's habit. And if you actually look behind the curtain, you can understand that, well, we've accepted it because nobody's really gone out there and looked at it and actually said, this is valid. These are the limitations of it. And so that's a big part of what I do, is working with experts who are starting to do that work and pulling that into the criminal system so that we can understand the limitations of that evidence in cases.
So what are some of the advances in that area of technology, ballistics, firearms evidence, and maybe talk a little bit about what you're going to be presenting at the Forensic Justice Institute in January?
So in January, what we're going to talk about is, what does that challenge look like in a criminal case? What are the different aspects we should be focused on to understand why this stuff is not reliable, and how should we convey that to a court? I'm also going to talk about some of the recent wins in other jurisdictions that you can pull into your litigation so that you can tell your judge, you're not alone in this. Judges around the country are starting to delve deeper into this topic and understand why this is not reliable. So that's a lot of what we'll talk about in January.
What's an example, if you could give me one of those wins from another jurisdiction?
There was a great win in the TIBBS case. It's TIBBS, TIBBS case out of Washington, D.C. And they did a fantastic job of lining up the experts for the court who could understand, what does it look like to validate a scientific method? Why is this not that? Why are all the studies that the government offers in these cases actually not valid to show that this has been scientifically accepted by the community? Instead, what we have is a lot of firearms examiners who are telling the court, this is valid because I think it's valid, as opposed to doing proper studies to isolate variables and then study those variables to see how effective we are at measuring certain outcomes. So the TIBBS litigation is a really important case because the court in TIBBS went through and talked about all of the problems with firearms comparison evidence and why it doesn't measure up and why it needs to be limited before we hand it to the jury.
Interesting. And so that was an exercise almost in the science of science, right? Or the procedures of science. You can have all these experts who maybe know a lot about firearms, firearm comparison, but by what process do we assess that expertise? And
that's right. And that's a really good way to say it, actually, the science of science.
Interesting. Have there been any scientific advances in ballistics technology? Twists and grooves, people looking at close-up photos of bullets in casings. I mean, does it go beyond that? Is there spectroscopic analysis as far as grains and bullets and that sort of thing? Or
for the most part, what we see in cases right now, what's coming into criminal cases is the law enforcement finds a bullet or a casing at a crime scene. They hand that off to the state lab. The state lab person also gets a weapon from a suspect, does some test fires, and then looks at those bullets or casings under a microscope and says, okay, the marks on this one are sufficiently similar to the marks on this one. That's enough for me to say a match based on everything that I've seen over the course of my career about how many marks should match. There's no actual standard for the number of marks that match. It's all independent by examiner. So if that examiner believes that those two things match, it's a match. And that's what the method is. What we're starting to see is more and more folks coming into the conversation who are trying to elevate the science and move it to something that's more scientific, more objective. So they're starting to look at things like virtual microscopy. So computer programs and algorithms that can actually measure the marks that they see and start to determine how many of these are actually matching, how many are not, how many are we seeing over time that look a particular way to tell us that yes, they came from the same source, or no, they didn't come from the same source. So we're starting to see more and more algorithm type work, but that still hasn't been validated. So what we're seeing in the courtroom is the first type, the sort of manual comparison using a microscope.
And it's fascinating that it's that subjective, I guess, of necessity up till now, because the science hasn't been there for whatever reason. But I had no idea it was that subjective. I mean, that almost sounds like my grandmother's recipe for cornbread. A dab of this, a dab of that, and she's been doing it so long it comes out, it tastes great. And if you cook it enough times, you'll get there too. But there is no recipe, or the recipe is but a guide. And for making cornbread, that's fine. But it sounds like there needs to be a more objective standard for the assessment of firearms evidence in a criminal case.
That's right. I mean, right now, what it is you know it when you see it, and that just can't be enough to take away somebody's freedom.
Wow. Well, I look forward to your panel, Janis, at the Forensic Justice Institute. It's January 20 and 21. Should be a fascinating discussion, and hopefully the weather won't be too cold when everybody comes here in January. So thank you again for your time. Looking forward to meeting you in January.
Thank you. I appreciate it. Bye-bye.
Okay, bye-bye.